Thank you. Good morning. It's a pleasure to speak about the IP strategy. You already gave away the secret. What does IP actually stand for? Intellectual property. That's not the legal dictionary definition that you see on this slide here. It's how I like to think about intellectual property. In a broad sense, intellectual property encompasses your intangible assets, reputation, data, knowledge, collaborations. You could include customer relations, you could include people. So everything that makes your company valuable on the intangible side. On a more narrower side, the legal side, you have patents, trademarks, the traditional IP rights. And because often there is a lot of confusion about what these are, I'll give you a 1-minute crash course in IP. So patents protect technical inventions. Copyright protects works of art, and more importantly for you, software code. Trademarks are for your brands, slogans, logos, designs protect the outer shape of products or packaging. There's one main difference, right? Copyright comes into existence when you create, when you code, for instance, when you write a book or develop a piece of music. The others need you to do something. You need to make an application, go through a registration process, examination procedure, and in the end you have something that's different in certain countries, but that's the main concept. But they have commonalities. They are property rights. We just heard real property. Well, that's real property too, it's just not tangible. That means you can sell, assign, lease this property. That's what we call licensing. IP rights are exclusion rights. They are not rights to do something. That's very often confused in practice. And they are territorial. Simply said, no right in a certain country, someone else can practice your IP there. In that scheme of IP rights, you should also include know-how, secret knowledge, and trade secrets, but this is shaped a bit differently because it's not really a property right. Anyways, with that introduction, I would usually jump directly to the strategy considerations. But I'm mindful that in tech, fintech, software industry, people sometimes have interesting notions, such as tech players don't need any IP. That's for the life sciences guys, right? Software is not patentable, or open source software can just be used. Are these notions correct? First one is utterly wrong. If you look at the top 10 international patent application filers, guess how many pharma companies are in that list? I don't have a bottle of wine to give you, so I'll answer myself. 0. 0. The players in that list, Huawei, Qualcomm, Samsung, LG Electronics, Mitsubishi Electrics, and you can go on for a long time in that list. Second one, source software is not patentable, partly correct. Code as such cannot be patented, but computer-implemented inventions can be. There are numerous patents on applied algorithms, machine learning, data security, authentication processes, process control, and so on, and so on. So that notion is correct, but it's dangerous. Third one, obviously wrong. You just learned copyright comes into existence when you code. The open source just tells you how you're allowed to use it. It's not nothing. With that background, you're certainly ready for the IP strategy now. In practice, very often, IP strategy is initiated by a CFO. Why? He wants to save cost. That's a valid reason for an IP strategy, but it's not the best one. The best reason for an IP strategy, the best goal, the best starting point, is to start from your business strategy and to align the IP strategy. Why? IP that is not needed for the business is not worth it. IP that would be needed and you don't have can be detrimental. So my favorite situation is that someone from the strategy team or in a startup business development, and the developers talk together at the same table. You look at the markets and you look at your capabilities on the technology side and you bring them together. That's the ideal situation. First thing you should ask is, what's the purpose of my IP? Is it commercialization of the IP as such? We'll look at a few examples later on. Is it competitive advantage? You want to sell more? You want to obtain higher prices? Is it pure image marketing? Make your company look nicer? Have a nice portfolio? Or is it tax advantages? Patent box in Switzerland. Quite interesting, but it requires totally different IP than if you want to commercialize your IP as such. Let's look at some models. Model 1, monetizing IP as your business purpose. That's your business, right? Famous example, intellectual ventures. They call themselves the Invention Investment Fund. 1,000 transactions, $3 billion, all they bought is patents. And they're licensing them out. So that's a valid business purpose. Some people call that patent aggregators, or less nicer words. That's a very successful company, right? Rather the exception than the rule, but what you see much more often is that IP is sort of a business unit. Monetization of your IP is not the sole business purpose, but it's a business purpose. Famous example, Nokia. The people in my age remember that we had Nokia phones before the smartphones came out. Nokia didn't really match the smartphone market in the beginning, but they had a huge patent portfolio, 3G standard. So they monetized that, and they still do, with a very successful IP strategy. So it's part of their business. The Swiss example, Kudelski, they're actively saying on their website that they are commercializing on their patent portfolio through cross-access and licensing. When is this model valuable, particularly for smaller companies? For instance, you have a nice portfolio, but you don't have the technology to actually practice the portfolio. Then you can think about out-licensing part of that portfolio. Or more frequent, you don't want to enter a certain market, US, because it's too risky, but you have patents there, you have rights there. Why not license them out for the US market? That's model 2. Model 3, the traditional model, IP is there to support the sale of your product or services. Most tech players have this kind of strategy. And then there are some, what I would call thought leaders, such as Siemens, who actively promotes even scientific approaches of having an IP strategy. So here's a link to a paper if you want to read it, Why Digitalization Needs Value-Driven IP Strategies. Okay, value-driven IP strategies, that's the buzzword that is used by the larger industry players. And then you have model 4, no own IP. Well, you just learned that's not possible. You will have knowledge, you will have a brand somehow, you may have code, but in this model, you just don't care, right? It's a fair strategy, but it should be deliberate. If you take that strategy, take it consciously and not negligently. If you look at your own IP, you decide you want to have IP, what are the key points to preserve your assets? As we've just discussed, fitting the business purpose is crucial. So model 1 to 4, purposes, and this then determines how the quality of your IP should be. There is a difference. You can have high-end IP, you can have simple IP, easier, cheaper. So there actually is a difference. And the scope, particularly territorial scope, often for startups, after 30 months from filing your patent applications, you have to decide where to go, which country, and that's costly. So if you don't have a strategy, then you'll probably not take the right decision. Another important topic, ensure ownership. Make sure you own the IP you want to own. That's very often an issue in startup companies because you have a developer in Belgrade or somewhere else, but you still think you own the code. Take care of the contracts, okay? IP is something that originally is owned by the creator, and then according to the legal system, it's transferred to the employer or not. You take care of this, right? And do a cost-benefit analysis regularly. In practice, we often see that when you start small, it's all clear, it's all aligned. The larger you become, the more product developers you have, the more business developers you have, and the more salespeople you have, they stop talking to each other, right? So what actually the market wants, the features from your product that are crucial on the market, might not be what is protected in your IP anymore. So bring these people together and have them talk. To a proper strategy, of course, the flip side is third-party IP. How do you deal with that? Risk mitigation, simple thing, awareness. In an early stage, it's easy to monitor your competitors. You know them. Okay, every company knows their fiercest competitors. Set up a monitoring. Look what they do. It's simple. More complex, more difficult, freedom to operate. If you really want to look if you are allowed to do what you do. We've heard in the beginning, having your own IP rights doesn't mean you can do things. You can just include others. That's a difficult topic. Something to be done if you want to launch an important product and invest a lot of money. Compliance, if you are in IP minefields, have an in-licensing strategy or an open source policy, and don't give away IP infringement indemnifications easily. That's easily done, very costly if they materialize. Very often, if you are aware, if your technical developers, technical people are aware of IP, problematic third-party IP early on, there are alternative technical solutions. But you need to implement them before you have your product finalized. That's why it's so important to think about these aspects early on. How to? When you invest, you could look in the due diligence, whether these aspects have been covered by the target. In my previous life in a large law firm, I've done a lot of M&A transactions and a lot of due diligences, and never ever was there someone looking at the substance of that stuff. You know, someone was just ticking boxes. There are 10 patents, 15 trademarks, maybe some contracts, and you felt fine. That's not what I'm talking about. Also, it's not the key part. If you invest in a company whose real assets are IP, then that's something you could think about. If you are in the position to actually do an IP strategy, start with the business strategy, look at the markets, the competitors. Based on this, what you can do is determine what I call an IP target state, a vision. That's where we want to be in 5 years, on core products, on extended products, and on future products. IP is always ahead. You're 2 years ahead of what you're actually going to have on the product line. So you need to think ahead. When you have the target state, you can have an actual state, take a comparison, work on an implementation plan, and review regularly. Once done, it's an easy review. Once a year, it's not more required. Once a year, take the stuff out, look at if it's still valid, map it, adjust. Has the competitive landscape changed? Have our products changed? Has our market changed? Are there any new competitors? And adjust. Not a big thing to do, but a rare thing done. With that said, I conclude my speech 30 seconds early. Thank you very much for listening, and I'm happy to discuss any questions or considerations you could have in the breaks.
Thank you so much for sharing. Thank you. Absolutely wonderful.